All right. Good morning, everybody, and thank you for joining us today. Our webinar originally was scheduled today to talk about assignment sales. We've revised the topic a little bit, and I have David Woodside here joining me today. He is our in-house lawyer from Coach House Law. Welcome, David. Thanks for joining me today.
Thank you. Hi, everyone. Hope everyone is holding up and staying healthy and staying sane. It's an unprecedented time, for sure.
Absolutely. Yes, it is unprecedented. And one of the things that we're going to start off talking about is how to deal with this from a legal standpoint. So let's just jump right in. First of all, I'm sharing here your contact information. So I'll let you give out your email address and direct phone number if people want to reach you directly.
I appreciate the promo. I'm actually just at home working in a little corner here. If you guys hear any weird squeaks or noises, it's probably my 6-month-old baby making noise downstairs. But this is a weird time to be going through anything. Real estate is no exception. What you need to keep in mind mostly is that we don't really know what's going to happen. So trying to build as much flexibility into real estate contracts and being patient with each other and being understanding is going to be really important. I guess I'll sort of start from the legal side, and I'll work over to the real estate side. So from discussions with my colleagues and other law firms, what most people seem to be doing and what we're doing is we've gone almost 100% remote. We have one assistant working in the office and everybody else is working remotely. We're doing all wire transfers, electronic fund transfers, video conference meetings. Whenever possible, we try to sign documents electronically, but that's not always possible. And what I can talk about later is that I know in real estate, it's generally accepted to sign all documents by DocuSign, and that's fine. But at the close of a transaction is sort of the last line of defense against fraud and verifying people's ID and things like that. So we're a little more strict about the use of electronic signatures and even video conference for that matter for signing documents. So with clients I know and trust, that's no problem. With new clients, we're going to have to be very careful to verify identification. It's arguable whether you can do that through video or not. So we're going to try to do that. And also signing documents, generally we'll have video conferences, have clients print off documents, witness them, sign them by video conference in front of us, make sure they're not signing under duress or undue influence, all the basic legal requirements, and have them scan documents back to us. We're limited by requirements of things like the bank. With mortgages, most banks require borrowers to meet directly with a lawyer and sign in person. So that makes things more difficult. But title insurance companies have waived certain requirements. I'm told, I've heard that Stewart Title is waiving requirements for in-person signings, and they're also extending gap coverages. So if a real estate deal needs to close and the land registry open and able to register, then we can close an escrow for a small amount of time and have insurance coverage for that. So just going back to high level, real estate deals can continue to close and continue to happen as long as banks stay open for advancing mortgages and as long as the land registry stays open, and so far it has. And I think these things require minimal human interaction and minimal people these days, so they are staying open. I can imagine what it might have been like with a non-digital version of the land registry where lawyers used to meet in person at the registry office and stamp documents and things like that. It might have been a different story, but everything seems to be open and continuing. But let me jump more into your wheelhouses. As practitioners, having your feet on the ground every day, trying to buy and sell real estate for your clients, there's a number of things you might want to consider in drafting agreements of purchase and sale. One thing to think about here is that obviously all of these things are driven by market forces. So lately it's been a what you would call, I guess, a seller's market. People, and it's been like that for quite a while now, people are buying properties, seeing them once, no conditions. All of these things are terrifying for a lawyer, but that's sort of how it's been operating. I don't know if it's going to continue to operate like that. I would be curious to hear from you how you're experiencing the market these days. I mean, I'm no expert in that respect. I sit behind a desk and I'm closing deals that people have signed months ago or weeks ago. But I have heard from realtors I deal with that there are still multiple offers going on and people trying to, you know, act like it's still a seller's market, which it might just continue to be. It definitely seems like it's a good time to borrow money. Mortgages are at an all-time low interest rate, and the government is making exceptions for payment, delayed payments and things like that. So borrowing money might keep the real estate market trucking forward at a very competitive rate, like it has been. Who knows? We'll see. But that being said, if it's possible, you should definitely alter your drafting of agreements a bit to take account for this pandemic, this crisis. So let's see here, suggested clauses, everything that requires people to meet in person, it would be good to put clauses in the agreement, because the starting point is the agreement of purchase and sale. This governs the entire transaction. And if it's not in the agreement of purchase and sale, in most cases, a buyer's hands are tied and a seller's hands are tied. They have to follow it. And it's really difficult to negotiate exceptions to signed agreements after they've been signed. Also, a note on that is you should definitely make your clients aware. I mean, you should be always doing this, but these are serious agreements. When you're signing an agreement to buy a $1 million property, it's pretty written in stone. You will be held to it. So if you don't think you're going to be able to close, put some conditions in there. Arguably, if the economy is trucking along the way it is, just because there's this crisis won't necessarily make it acceptable for someone to walk away from a purchase agreement they've signed. So that's something to keep in mind. We have a couple suggested clauses here that Jane's put in, and they all seem really smart to include in these agreements if you can. So number one, acknowledging, I think this is the first clause everyone always puts in Schedule A on the agreement of purchase and sale, which is how the balance of the purchase price will be paid, and just make it clear that that will be done by wire transfer, electronic fund transfer. Just so when a deal is closing, a seller's lawyer can't insist on funds to be paid by, you know, certified check or something like that, which you'll laugh, but in this day and age, a lot of lawyers still insist on operating by couriered certified checks and things like that, rather than accepting wire transfers. Just as an aside, one thing we're dealing with is, and Jane, I'm rambling a lot here, so just tell me to, you know, if you want to hop in anytime.
I'll jump in with some questions. We have some rolling in, but I'll let you carry on. I don't want to interrupt.
Okay. Well, people are always interested to hear these things, or not interested, but one really timely thing we're dealing with right now is when you're paying out a mortgage. So for example, when you sell a property and you're going to pay out that client's mortgage, all the major banks still insist on having mortgages paid out by a check sent by courier to their back office or delivered to a branch, which seems really bizarre in this day and age. They won't accept wire transfer. I've just been having several conversations with bank employees trying to convince them to figure out a way to accept payments for mortgages by wire transfer rather than having to courier them or go into a branch. That being said, there's third-party software that's been developed that you can use to pay out mortgages, but those all end up costing extra for your clients. But anyway, going back to purchase price, just make sure that sellers will accept payment by electronic means, which is actually the safer, more direct way to do it anyway, rather than a certified check.
So that is basically the addition there, right? Is the addition of the wire transfer ability?
Yeah, and I think the standard clause that everyone puts in there should be sufficient anyway, because it mentions I think the large value transfer system, and I think that does technically include or mean wire transfer anyway. But this is just more specific, and it also shows that would help show your client you're thinking about what's going on here. You're not just throwing in random clauses because you do every time. But yeah, that's a good one. The next one is paper closing. So this is another standard clause that most people include, but just acknowledging that things can be signed electronically, and that all closing documents can be signed electronically and sent by email or fax rather than original. So this is a very useful one to have as well.
Okay, you mentioned at the beginning that typically closings, you do them in person unless it's somebody that you know. If it's not somebody that you have met before, is that still something that you would do given the circumstances?
So in short, we're still doing things, but we're doing them electronically. Unless our sort of fraud radar goes up, then we may not want to continue with the transaction. But we will verify someone's ID remotely. We may ask for extra copies of ID, and we may want to see very legible versions and meet with them on video conference, but we are still doing that. And there is debate amongst lawyers as to whether or not, and the Law Society, as to whether or not that's acceptable. And the Law Society has sent out several emails about this already, and they're saying that, not to bore you with the details, but at the end of the day, they're saying it's always a risk, and you always have to be careful that you are properly verifying people's ID and witnessing them sign. So it's really up to the lawyers, but in most cases, we're moving ahead electronically unless we feel that there is something wrong happening with the transaction. But this is a good clause to have, because then you can, if one lawyer is refusing to accept electronically signed documents, we can rely on this and say, look, all the clients sign this and everybody is okay with electronic documents, so you can't insist on us sending originals. We can definitely send originals later. It's just to get the deal done, we may not want to be having that much in-person contact. And then transfer of keys. This has been a big issue. It sounds funny, but I mean, in this day and age, we're still very dependent on keys, even though there's so many electronic ways to get into properties with lock boxes and smartphones and everything. But in some ways, having an actual key in your hand is such a big deal when it comes to buying property. Like, people don't feel like they own the property until they have the keys. And
that's so true.
Most of these deals are kind of non-eventful. I mean, you sign all the documents and your lawyer calls you and says, congrats, you own the house. Having the keys is kind of like the one sort of physical, tangible aspect of this. So, and practically, you need to be able to get into the property. So this is a great one, requiring that a lockbox be left there with the keys, and then we can just give the code to the buyer once the deal closes, and they can go use them. I think this is a great solution. The problem is that often condo buildings don't allow lockboxes to be left, or they're very hard to find. So there's other solutions, leaving a key with a concierge, but people don't want to have to interact with the concierge. Or another thing could be for the sellers to courier the key directly to the buyer after it closes, so that minimizes interaction. And one lawyer has suggested, there's actually an online group where all real estate lawyers in Ontario have been sort of brainstorming ideas over the last couple of days. But one lawyer in this group suggested that we all agree to have the seller meet the buyer and give them the keys after closing, and with a holdback of $400 to $500. And if the sellers don't give the keys to the buyer within a certain amount of time, like 6 hours, then that money held in trust is given back to the buyer so they can afford to hire a locksmith to change all the locks. I don't think that solves the problem, because you still have to meet buyer and seller, and people are uncomfortable about that. So I think I think this clause is a good one. This is simple, but I'd leave that up to you and the seller, depending on the situation, because some properties may be different, and sometimes buyers aren't even anywhere near the property. They're in another province or another country and things like that. So it may be hard for them to get the keys that way. But just keep in mind with, and I find when I'm dealing with realtors a lot with writing new clauses, if it's not a template clause they can pull out of the system to insert, they find it difficult to write new ones. Don't be afraid. Just use plain language and make it clear. Don't try to put in legalese or make it sound like a legal document. Just the most direct and simple way to write things is best in these agreements. So with something like this, this is a great clause, but if you need to modify it, be as clear as possible. And also feel free to call your lawyer anytime for advice.
Awesome, absolutely. And we did have a question about that. So we will be sharing these clauses. I will upload it to Workplace. I know Mahir has also added some additional clauses to web form, so I'm sure he'll take these and put those in there as well. So these will be available to you as suggested clauses, and yeah, use them at your discretion. We do have a few more that we'll share with you as well. So I'll let you take over.
Was there a question, or should we wait till the end?
There was a situation that came up. I think, yeah, if we save that to after the clauses, I'll read through that and we can answer it.
Okay. This is another good clause here. So delay of closing if third parties are unable to close. So this would come into play if, well, if the land registry were closed, if banks were unable to fund mortgages or accept payments for purchases and things like that. And it's good to have, so it doesn't provide any confusion on what would happen. So basically, and you can modify these as well, but you can, this would allow automatically for the agreement to be extended until these services come back on, and then you can limit how long the delay happens. So this is a good one to have, but if it does provide a timeline and a final interval. So if it keeps extending, then the agreement would terminate and deposits return to the buyer. This can be used if you think it's useful, but then again, you could have one that just preserves the deal indefinitely, which is dangerous because we don't know how long these types of shutdowns or emergencies would last. It could go on for 6 months, could go on for a year, 2 years. So it's good not to have things that extend indefinitely. It's always good to put a time limit on things, but this is a good clause to use, and good to also contemplate if this happens, because it could be very likely that the land registry shuts down if or banks aren't funding mortgages or not open for accepting transfers and things like that.
For sure. We do have a question that came in, which I think is relevant. So I'll ask now. Have you seen any delays in closing?
Right now, no, but I've seen a lot of my clients trying to move their purchases up. So for example, one of my clients, they were scheduled to close in mid-April, and they wanted to close this week as soon as possible. So the seller was very cooperative, and they were actually closing tomorrow. But the buyer's reason was that they were nervous that if they lost their job and didn't have any income, they may not qualify for a mortgage anymore. So they wouldn't be able to purchase the property. And that, for some people, if you're in certain industries, or all of us, we all work in the economy, and if the economy shuts down, we might not have any income, or we might lose our jobs. So mortgages are directly related to your income. And banks can call them at any time. So even an hour before they fund, even if you've signed all the documents and the mortgage looks ready to go, bank's underwriters can always pull the rug out from under you and cancel the mortgage. So that in this situation, if somebody doesn't have any income, they could do that. So So my client was worried that if he did lose his job, they wouldn't be able to get a mortgage and get this property closed. So he wanted to close right away, and we were able to do that.
That's a great point, something that I hadn't considered. So for those of you who are listening, if you have closings mid-April, that might be something you might want to address with your clients. So we do have some questions coming in here. So if representing buyer, why stipulate the either party may terminate?
Good question. And you hit the nail on the head. If you're representing the buyer, just make it the buyer who has the control of the situation. However, this one is, I think, designed to be a little bit more neutral rather than pro-buyer. And obviously the seller could have issues on their end. Maybe their lawyer's bank is closed and can't accept transfers, or you know, the buyer seems to not have a problem with closing with the registry not being open, and the seller may elect to do that. This is actually a situation that happens often when there isn't a crisis. Is all of the standard OREA, agreement of purchase and sale agreements, allow closing up to 6 p.m. on the day of closing. If you read those contracts, it'll say 6 p.m. But the land registry closes at 5 p.m. every day. So if it's sort of 4:30 on a Friday afternoon, and the mortgage hasn't funded, and it gets to 5, and then the mortgage funds, and then you transfer funds to the other lawyer, and everything's done, but you can't actually register the property because the land registry closed at 5. A lot of times what lawyers will do is, if both are in agreement, we'll close an escrow, which basically means that we're acting as if it's closed. Seller releases funds, buyer's lawyer gives the keys to the buyer moves in, and they agree to register the property on the next day that the land registry is open. And title insurance, this is very important. Title insurance obviously provides gap coverage. So if something were to happen between the time that you close an escrow and you actually register, title insurance would provide insurance coverage. So that helps mitigate risk. I don't know how that would work if, say, the land registry is closed for 2 years, but if the land registry closed for 1 day, you could close an escrow. And sometimes if the buyer might want to do it and seller doesn't. So if they can't both agree, then you can't do that. But in this clause, for example, if the seller wanted to extend, they could do that, because back to the question, it says either party. So if you wanted to make it more pro-buyer, have the buyer more in the driver's seat, it would be leave that discretion up to the buyer.
Okay, perfect. Thanks for answering that. So yeah, you were mentioning title insurance. So here's another one.
Delay of closing and title insurance. So I'm just gonna scan this one again. Okay, so this is if something is delayed because of the pandemic, the buyer and seller hereby agree to extend the completion date of this transaction until the next possible date following a scheduled date of completion. That registration could actually be effected with no charges being made to the buyer. Notwithstanding the foregoing, in the event the buyer's title insurance has provided gap coverage to the buyer and all closing funds have been paid to the seller's lawyer and trust, keys may be released to the buyer with title. Okay, so this contemplates what I was just talking about. So yeah. This could be used instead of the previous clause. So if something happens that you can't close, basically you're going to agree to close on the next available date. However, if title insurance, which most title insurance companies are providing this now, if they provide gap coverage, you can close an escrow, act as if, and then the lawyers will close the next possible day. And I mentioned that why do you have title insurance for gap coverage? Because there's a big risk. If you now have actually sort of sold the property as a seller and you have the money and the buyer has the keys and they're living in the property, but it's not yet legally transferred into their name, things could happen before that gets transferred into their name. So for example, maybe some kind of lien gets thrown on the property, or the seller or somebody impersonating a seller puts a couple other mortgages on there and you go to close and you don't have clean title. that's a problem, because you don't, as a buyer, you don't want to accept the property with a bunch of encumbrances or liens or mortgages or problems with title. So if something happens to title between those two instances, title insurance would cover you. And I'm obviously explaining that in a very simplistic way. And title insurance companies, like any other insurance company, have a whole bunch of exclusions, and often they may not want to pay out on things, but usually they're pretty good with things like that.
Okay, great. So this is an either or, this clause or the one before, not both, obviously.
Yeah.
Okay, and I think this is the last one. The automatic delay of close if either party is quarantined and cannot sign.
Very interesting.
Yeah.
Yeah, this kind of underlines the crazy and scariness of what's happening right now. I mean, reading a clause like this a month ago or 2 months ago, you probably would have thought, why would I ever be using a clause like this? But here we are, and being quarantined is a very real thing. My one issue with this clause is that there's no definition of quarantine. So there might be some debate about that. I mean, right now there's voluntary quarantines and self-quarantines, and I don't know if there's state-imposed quarantines in Canada yet, but maybe if you flew on an airplane back to CFB Trenton off of one of those cruise ships, you're just state-imposed quarantine. But so just to avoid ambiguity here, I would maybe define quarantine or not. I mean, we don't have to, be that harsh here. If you're self-imposed quarantine, we're not going to force someone to come out of their home if they think they have the virus. But we always like more clarity as lawyers here, so we don't get in a weird fight over this. But basically, if you're quarantined, there'll be an automatic delay of closing. If this clause is invoked, the buyer and seller shall continue to act in good faith and use their reasonable best efforts to ensure the completion of the transaction occurs on as timely a basis as possible, and will not use this as a means to delay closing in anticipation of any such quarantine or closure, or for reasons unrelated to COVID-19. So there's a bunch of sort of legal catchphrases in here that lawyers would hang their hat on, and realtors would hang their hat on. So one of them is acting in good faith, reasonable best efforts, and timely, and there's also a phrase that it's clear that this can't be used for reasons unrelated to COVID-19, and time shall remain of the essence. So it puts some responsibilities. You have to be acting in good faith. So that means coming with clean hands. You shouldn't be trying to hide behind this clause or lie or mislead people with regards to this, as you always should never be doing those things. And use your reasonable best effort. So reasonable, there's a reasonability test here. So if I'm just trying to think of an example, maybe somebody goes out every day and meets all kinds of people, but then they're saying they won't sign documents because of this. That doesn't seem reasonable.
Right.
And timely means as soon as the next available time it becomes available, you should do it right away. But yeah, this is a clause that can be used in addition to one of those other clauses.
Perfect. So I lied. We do have a few other clauses. We did address them in the last webinar that we did. And this was about showing clients properties virtually. So instead of meeting them in person, and then if they did want to submit an offer, basically, how do we put in a condition that they're still basically allowed to look at the property? And Kevin had recommended putting it in as a home inspection, and that would be the time that the buyer would also have an opportunity to personally inspect the property if it was previously a virtual tour. And then he did suggest an escape clause as well. So those were previously mentioned, but I'll just pull it up here. I don't know if you have any comments about this or alternatives.
I'm all for conditions. So I think, in a seller's market, sellers don't want, and competitive offers, sellers don't want conditions, but conditions are buyers' friends here. So, allowing for, buying a home by video conference isn't probably that much more risky than the way people are buying homes now anyway, by looking at them for 5 minutes and not having home inspections. I would always advocate a home inspection, be thorough. These contracts are serious. You're committing a lot of money to these things. So do your due diligence, because once these contracts go firm, again, in a lot of ways, buyers' hands are very tied.
For sure. Thanks for that. So let's get to the question here. So it's a situation. So I'll just read the comment and then we can go from there. So one of our agents sold his client's home, which is tenanted at the moment. They agreed with the buyers on vacant possession, sent out the N12 with registered mail. The tenants were to move out March 28th in preparation for an April 1st close, but now they've stated that they do not wish to move at all. Are there any courses of action to be taken here? I know the LTB will probably not carry out eviction orders for the time being. Is the closing going to be delayed?
I've been dealing with a number of these situations lately. This is a difficult one. As far as I know, I think the landlord-tenant board is suspended right now with the other courts and tribunals. I think they'll be back open eventually, but I've also heard, and I don't know exactly if this is happening, but no evictions are going to be taking place during the pandemic, apparently, or even if they are permitted, I don't think people are going to look kindly on someone trying to evict someone during this process. There is that aspect of landlord-tenant board. It is subjective. So it's up to the buyer and seller. Does the buyer want to assume the property with a tenant and then take that problem on themselves, or take on that responsibility themselves? Or do they want to delay? I mean, if the contract says the seller will provide vacant possession and they can't provide vacant possession, then the buyer and seller can delay closing until vacant possession is available. So they could come to that agreement.
Okay, great. Thanks for answering that. And thanks for the question. If you guys have other situations that you're in that you would like answers to, please drop them in the Q&A chat with us. Otherwise, we'll jump into what we were originally scheduled to discuss, which was assignment sales. So I'll just skip over this escape clause. But yeah, as mentioned, this is what we were originally going to talk about. So I know I've already asked you a ton of questions, but if you can give us, just let us know, what assignments are, the different types of assignments, how they work, and hopefully some questions come in about this would be great.
Absolutely. So very high level, an assignment is when someone signs an agreement of purchase and sale. And after that point, but before closing, they essentially sell that contract to somebody else. So another buyer shows up and hops into the shoes of the original buyer and fulfills the obligations of that contract. So they buy the contract and then they go and buy the property from the seller. This can happen in just regular freehold property sales with an agreement of purchase sale. Somebody else assigns that to somebody else. The most common way that this happens in Toronto is with pre-construction condos. And I think I'll focus most of my discussion on that, and just because I think for the GTA, that's the most relevant. But that happens when someone buys from a builder or signs a contract to purchase, and then there's usually a time lag from when you sign a pre-construction contract. There's probably sometimes years before it actually closes. So during that time, the original assignee becomes the assignor and sells that contract to someone else, the assignee. So very quick example, say someone signs a contract to buy a pre-construction condo for $100,000 with a builder. Then a year goes by, they still haven't closed. They decide they don't want to buy it and they want to sell the contract to somebody else. So they sell the contract to somebody else for 50 grand. So basically that new person is going to go pay 50 grand to the assignor, and they're going to wait to go buy the property for 100 grand. So that new person, the assignee, bought the property, is going to end up paying 150 grand for the property that the person originally agreed to buy for 100 grand. So it's a very simplistic arrangement. These have become more actively publicized, even though most pre-construction contracts do not allow buyers to advertise that the contracts are for assignment or to list the property. Builders don't want people competing with them to sell their units. But with sort of the lack of supply in the market, I've seen lots of assignments being advertised on places like Kijiji or even MLS. So you got to be really careful. Most contracts don't allow you to advertise these. And if a buyer's caught advertising them, the builder can hold them in default, keep all their deposits, and resell the unit to somebody else. But as an agent, when you're doing these contracts, you can structure them a couple different ways. One, you can sell the contract to a new buyer, and that seller gets paid immediately for whatever the difference is, or it can be contingent on, they'll get paid on closing. And this is often more common because the buyer actually needs to get a mortgage in order to pay the assigner and the builder. So sometimes the assigner is willing to wait until final closing, and then the mortgage amount will be for the cost of the unit plus the cost of the contract. So those are sort of the two main ways to do it. What you have to be cognizant of is, number one, most of these contracts, if not all, require the consent of the builder, the vendor. So you can't actually have an assignment happen unless the builder agrees to it. So you have to ask the builder for permission. They usually have some form of consent agreement that they want everybody to sign, and they'll issue it. And often they'll have an assignment fee that you'll have to pay, if not just their legal fees, before they'll do it. And most of these clauses usually only allow assignment if a certain amount of the units have already been sold, and the vendor can decide to withhold that consent arbitrarily often. So it's not always a sure thing that you'll be allowed to assign a contract. But when you fill out the OREA form for an assignment purchase, usually you would make it conditional on obtaining vendor consent. So you sign the agreement, everybody is ready to go. The assignee, the buyer here, puts down a deposit, but it's conditional on getting consent of the vendor. And sometimes that consent can take a couple of weeks, if not more. And then once the consent happens, then the deal is firm.
Perfect. And then who pays that developer fee?
So you can negotiate that in the assignment agreement, but typically the assignor, the original party to the contract, is going to pay that. But you should stipulate that in the contract and just be clear about all fees. So, and just another thing to think about is usually the person who signed the contract, the original buyer, has already put down a couple deposits on the contract. So they're going to want to get paid those deposits back. So the new buyer, the assignee, will take over that contract and already have a credit for those deposits. So just assume all of the liabilities and all of the benefits that the original buyer already had. They'll then, if there's a deposit schedule and there's 6 deposits and the original buyer already made 3, they'll then get the contract. They'll assume the benefit of those 3 deposits and then start paying the 4th, 5th, 6th and go ahead with closing.
Okay, and then what about HST?
So good question. HST, if we're talking pre-construction, new property, HST is always due. So under most like Ontario condo pre-construction agreements, they usually include HST in the price on the contract, but the price includes the HST rebate that has been deducted. So that's something to think about. So whenever you buy a new property, like buying a new car, you have to pay HST, but there is an HST rebate in Ontario and Canada for new homes. So you do get a rebate, and most of the builders already take that rebate out of the price and you assign the rebate to the builder. So you never pay the amount of the rebate and you never get the rebate. It's just the builder collects it on your behalf. But okay. Sometimes when you assign, the builder will not give the new buyer the benefit of that rebate. So they'll basically add, when you go to finally close, you'll have to pay the rebate amount. So they add it back into the price. So usually it's an additional 24 grand, and then you can go and apply for it separately. And I've seen that a lot lately, especially with like Concord. they're not including the HST rebate for assignees. So just read the fine print in your assignment agreement if you become a new buyer and assignee, because you might have to pony up extra cash on closing.
Okay, so the HST, so in that example that you used before, the HST would be on the original $100,000 purchase price?
Yes, on the original price. So if in that example, if it were a condo in downtown Toronto pre-construction, that 100,000 would already include HST, and also have the rebate deducted. So if they weren't eligible to get the rebate from the builder, basically the cost of buying that condo would be approximately 124,000 because they'd add that amount back on.
Okay, and then we have another question here about the form that needs to be used. So it's not the regular agreement of purchase and sale, correct?
Yeah. So there's the last I checked, and I know there's a lot of educational seminars out there about the standard Ontario Real Estate Association forms, but I think there's an assignment of a condo form, and there may be an assignment of like a freehold property form as well.
Okay, perfect. Yeah, so there's a different form for this. And then is there a clause to protect your client from that 24,000 HST surprise at closing?
Unfortunately, no, because this is up to the builder. So you got to think of it in a way that the builder has already signed a contract with a buyer, and now the builder doesn't care. They don't care about a new buyer because they've already sold the condo, so they can kind of dictate these terms. So if the builder says we're not gonna give you the rebate to the assignee just has to accept it because the builder's not going to change. The only thing you could do is try and make the seller, the assignor, pay it. But why would they pay it? Because if you plan to move into the unit or have a family member move in, you're going to get the rebate anyway. It's just you don't get it on closing. You then go apply to the CRA and get it after, and it takes about a month or two. So the seller's not going to pay it for you because you're going to get a rebate no matter what. It's just you have to pay it, then get it back, or just not have to pay it at all. It just requires you to have greater cash flow on closing. So is there a way to protect your assignee from having to pay that? You can make it a condition of the agreement. So when you get the consent for assignment from the builder, you can read that consent agreement, and if it says we will not extend the HST rebate to assignees, then you can't have it. So then you may not want to go ahead with the deal if you don't have $24,000 you can part with for 2 to 3 months. Also, those rebates, you only get them if you're going to occupy the unit as your principal residence. If you aren't, you don't get the rebate, but there's a different type of rebate you can get as an investor. So if you're buying a condo to rent out as an investment, there's another type of rebate that's similar. It's not as much. I think it's about 18 to 20 grand rather than 24 grand, but you still can get a rebate.
Perfect, thanks for that. And then we have a couple of questions about commission. So do you know how that is calculated? Is it on the original purchase price or
Good question. So obviously it can be negotiated however you want, but typically, and I feel like these are great things there's a little more work involved in assignments, but they're great for agents because you get commission on the full assignment value. So in my previous example, if the original contract was for 100 grand and you sell the contract for 50 grand, so the assignee is buying the contract and the property for 150 grand, the commission is calculated on the full 150 grand. Typically, I mean, there's a lot more flexibility here, and agents negotiate different types of commission on these all the time. But presumably you could double end one of these and get 5%. I mean, theoretically you could charge more commission if you wanted, or less commission. But that's sort of the norm. And another thing to keep in mind for your buyers is that a land transfer tax is calculated based on the total value of the purchase here. So in my example, the new assignee, when they go to close in 6 months to 6 years, when they go to close, they have to pay land transfer tax, not just on the 100 grand, they have to pay land transfer tax on the full 150 grand. So that can be a big difference, especially in some of these higher value properties. So if the original contract was for 500,000 and the assignment is for 1 million. So 500 goes to the assignor, 500 goes to the builder. You have to pay land transfer tax on a full million, not just the 500,000.
Right. Okay. Excellent. Well, thanks for that. Let me know if you guys have any other questions about assignments. We've already talked about the fact that it is a different form. Hopefully we can also upload an example of that onto Workplace so that you guys have that. But yeah, we have a few more minutes here with David. So thank you again for joining me today. It's always great having you on. I always learn so much. So there's always a good takeaway for me. So I appreciate you being on here.
Well, thanks. And anybody, if you have any questions, feel free to reach out. You can call me anytime, or email is usually best. Often takes me a while to respond to voicemail, but yeah, just reach out anytime. Happy to help.
Awesome. What's your direct email address and phone number?
So just, it's david@coachhouselaw.com. Just go to our website, coachhouselaw.com, and my phone number is 437-222-2055. Which is being forwarded directly to my cell phone these days because clearly not in the office.
You're getting all the phone calls. Awesome. All right. Well, if there aren't any other questions, we can wrap it up. And again, thank you so much, David, for joining me. And I know we'll be in touch. And thanks.
Thank you.
Yeah. Stay safe. And we'll talk soon.
Likewise.
Thank
Bye,
you.
guys.
Bye.